Hello and welcome to another episode of Rock the Closing. Today is a very special episode. We are super excited to welcome another guest. Today we have Bracha Etengoff. She is a trust and estate attorney in New York City and Long Island. She does mediation and estate disputes. And she's going to be talking to us a little bit about how real estate and trust and estate come together, how they can relate, how they can intersect, what some issues might be, problems, benefits, all the things. So we are very excited to have her. We will be posting her information on the website. So look out for that. And her website is brachalaw.com, BRACHALAW.com. Okay, so let's just get right into it. Arcelia, are you excited as I am?
Yes, I'm very excited. Bracha, welcome to our show. And I think that you will have so many important information for our listeners that I can't wait to hear what you have to say. But let's right away get into the middle of it. So what happens? And unfortunately, this happens, but what happens to the real estate when someone passes away?
So thank you so much for having me. It's a pleasure to be here, and I'd be happy to try to shed some light on this mysterious process. Like you said, we can cut through it, cut to the chase, and help people understand what happens and the control that they have to make sure what they want to happen happens instead of just some default. So what happens to real estate when someone passes, along with all their other possessions, is dependent on what plans they made during their life for their possessions distribution upon their passing.
Okay, sounds good. Sounds good. Makes sense. So that would be if somebody had thought ahead and planned ahead. Yeah. So what happens in the case of, I feel like a lot of people are in this situation when they don't have a plan or they haven't gotten around to putting it down on paper, a plan for what happens to their real estate in the event they pass. What happens then?
So that's a great question. In that case, the law has a default plan, and it might match your wishes and it might not. But the law says, okay, there has to be some rule about what happens if you didn't tell us what you wanted. And here's the way it often works. So say someone is married with a wife and two children. What the law will say is, okay, we presume that in most relationships that we know about, you would want your possessions to be divided between your spouse and your children. We also presume that you'd want your children's share to be divided equally among them. So the law says something like, all right, the first $50,000 in your estate, that goes to your wife. After that, everything is divided. Half to your wife, half to your children. Now, the half that your children inherit, each one gets an equal share. So what ends up happening there is half to the wife, a quarter to your first child, and a quarter to your second child, adding up all here to the whole of your estate.
Wow, that's really interesting, Bracha. But as I think all of us know, life is never so straightforward, and people may want to make a decision that is not what the law has them in, what the law foresees or prescribes. So, for example, could someone decide differently about the estate by having and writing a will? What is your view? What's your opinion? What would be the benefit of a will in a different scenario? What could you do and achieve with a will when it comes to real estate?
Okay. The one thing to keep in mind, and this is something you would have to discuss with your estate planning attorney. So an estate planning attorney or a trust and estates attorney, those terms are pretty interchangeable. What it means is someone who's going to help you draw up a will or a trust, which we'll get into a bit later. But the thing to keep in mind, which I'll just back burner that for you for your discussion with your estate attorney, is in New York and actually in all states in the nation, spouses do have inheritance rights. And your estate plan needs to either account for that, or you can have your spouse waive their rights. But I'm not going to tell you could do absolutely anything you want, and that's the reason why. So leaving that aside, say what you want to do is actually give everything to your spouse, because your children are 7 years old and 10 years old, and they won't be able to manage their own money. If they inherit it at 7 and 10 years old, the court is going to say, we need to appoint someone to manage that money for them. And you can only access it with our oversight. And it'll also say, okay, you get that straight out when you turn 18. And I have to tell you, Arsolia, there is really no 18-year-old who should be inheriting $1 million or even $100,000 with no strings attached. You're just not old enough to be able to make wise financial decisions on your own. So often people say, if my spouse is still living and my spouse is also the mother of my 2 children, I'm confident that they will take care of my children. I would rather have everything go to my spouse when I pass. And that's my preference. On the other hand, let's think for a minute. Some people stay married for various reasons, even if they're not living together, even if the relationship has concluded. Sometimes people stay married for another 10, 15, 20 years because maybe you need your spouse's health insurance. Maybe you just don't believe in divorce. And maybe you don't want anything actually to go to that spouse. There could be any number of reasons you don't want what is dictated to you in the statute of what should be the inheritance structure. There are any number of reasons you could not, in fact, want that to be what happens to your possession.
Wow, that's really interesting that you say that, because in my past life as a divorce attorney, I have met a lot of clients who stayed legally married to their spouse for many, many years after the relationship had basically ended. And I know for a fact they would have been really upset if they had passed and all of their property and their assets and everything had passed to that spouse. So it's great to have a plan for each season of your life, because things change, and then I guess you have to account for that in your future, because you definitely don't want to work your whole life and have something happens to what you work so hard for not to be distributed the way you want. So, and I also get a lot of questions about putting things in trust, putting property in a trust. I think a lot of times people ask about this and they don't really understand what that is or how it works. So can you shed any light on what the benefits would be of including property in a trust?
Mm-hmm. Yeah, that's a good question. So one incredible benefit of keeping property in a trust instead of passing it simply through your will is that the trustee, the person who you name to be in charge of the property in your trust, you can name someone to do that after you pass. So typically, people will often retain the power for themselves to act as trustee and manage all the property during their own lifetimes. But once they pass, what's called a successor trustee can take over. So let's compare a couple situations. Say you put your house in a trust, and upon your passing, the trustee can say, the market's really good right now. I would like to be able to sell this house sooner rather than later so that my family can get the full benefit here of their inheritance. Another reason I don't want to hold on to this property is none of us really want to live there. For example, if one of the trustees is a child and you've got a number of children, they live in different parts of the country. Nobody wants to live in this family home they grew up in. The longer you have to hold on to that house, the more your inheritance is frittered away, because for every day, every month, every year that you can't sell that house, you are liable to keep paying for its utilities, so electric, so gas, property taxes. And let's face it, you're the real estate attorney. So, I leave it to you to point out how the amount of money that you may be able to sell your house for now versus next year could be hundreds of thousands of dollars different, depending on what happens in the market, right? Is it a seller's market? Maybe now it is, but maybe next year, you're going to get $200,000 less for this house because it's been sitting and it hasn't been able to be sold. So if you're lucky and the house is in a trust instead, you can sell that house pretty much immediately.
Wow, that's so interesting. That's really good information, because I feel like a lot of people just have this obscure idea of how a trust works or what's involved, and they don't have a real clear picture. So thank you for that.
You have a trust that is separate from a will. It's a separate vehicle. It's a separate way of owning property. Then it can live a separate life. That house can live its own little separate life in that trust, far away from the courts, far away from waiting for the court to approve your will. You don't have to wait for the courts to appoint someone under the will to have the authority to sell the house. That house is happy, living its own little life, far away from the courts in that trust.
It's great to be able to have that control. Yeah, absolutely. To be able to manage your own property like that.
Exactly.
Yeah, that's amazing. So my understanding is also that there's more than one kind of trust. There are a couple of different kinds. Can you shed some light on that too?
Yeah. So usually we divide trusts into revocable and irrevocable trusts. So those are some kind of difficult terms, especially because they sound the same. But a revocable trust means what you might think, that you are able to revoke it. So a revocable trust, really, you can retain just as much control as if you own the property in your own name. So typically, if you have a married couple, they will own that house together in the trust, the same way they would have both been on the deed in their personal names. And they may both be acting as trustees during their lifetime. They can do whatever they want with their house in that trust the same way that they could do whatever they wanted if that house was in their personal names. That's usually what we use revocable trusts for. We want complete flexibility.
Okay, makes sense. Makes sense. And what about an irrevocable trust? What's the difference there?
Good question. So an irrevocable trust means you have transferred ownership to someone else in an irrevocable manner, meaning it cannot be taken back. You've made a permanent transfer or a permanent gift, and you don't retain the same level of control over that property anymore. It no longer mainly belongs to you. In the case of a house, you might be able to retain something like a life estate. And perhaps you would like to explain that to your listeners.
Okay, yeah, absolutely. So if you're retaining a life estate in your property that's in a trust, then you are basically promised to be able to live there for the rest of your life. Kind of like a lease that doesn't run out until you pass away. So that's a good way to make sure that you have the protections of a trust, but also the security that you won't be booted from your house, that you've put in this trust, and maybe the trustee is someone else. And so you at least have that ability to stay there.
Yeah, that's exactly so. And often these are used for Medicaid planning purposes, because while Medicaid may not take the house from the person who needs to go on Medicaid, right? Medicaid is going to let you keep your residence. After the person on Medicaid passes, the state may try to recover the money that they have expended for their care. And the state could put a lien against the house in which that person lived. So if this property is instead transferred to what's called a Medicaid trust, this irrevocable transfer has been made. The house actually didn't belong to that person on Medicaid anymore during their lifetime. It belonged to the children. And the person who was on Medicaid simply retains a life estate, a right to live there during their lifetime. And this is not a simple concept. And it also is not something that should be done without a full consultation with a qualified attorney so that you can look out for the different tax consequences and really make the best decision for you.
That's great. That's a good point, because I know a lot of people have that concern that they own a house, but and as they get older, what's going to happen to that house in terms of like when they need medical attention, if they're going into a home or something like that. So that's a great point. Arcelia?
Yes, Bracha, thank you so much. And I'm just listening here and learning so much from you. There are so many considerations. And you mentioned something before, and it comes up very often in real estate transaction. And I'm talking about capital gains tax. Because very often a family or a young couple purchases a home, and then they spend decades in that home. And then, as we know, in New York City or in New York State, the market is really growing. And perhaps you have invested in a home 40 years ago, 30 years ago, and then the price went so up with the market changing that you might be exposed to capital gains tax. So anytime when we are practicing as real estate attorneys, we always have to look and take this into consideration. Again, this mostly happens when there is a huge surge in the market price for certain property, or when a family has owned the property for an extended amount of time. Then we do have to look into for how much the property was purchased and what is the current selling price, and if there is a capital gains, which is, if it's owned by a single person, 250,000. If it's owned by a married couple, it is 500,000 or more is the gain. That is the difference between the selling and the purchase price. Then we do have to report that, and capital gains taxes will have to impact the seller, and they will have to pay a certain amount to the tax authorities. Can you help me understand a little bit what are the potential capital gains implications for real estate buyers who are using a trust? Because you have advocated in favor of a trust right now, but would capital gains tax now be also something that will apply to trust if the buyers are putting the house or the property in a trust?
Okay. So I'm going to continue to look at this through the lens of an inheritance, right? Because, that's kind of the track we're on here. So I'm going to focus on what happens if your children now receive that house after your passing, depending on the plan that you've made. What could be the implications on capital gains taxes? So when someone inherits property, when they inherit real property, they receive a benefit called the step up in basis when you get around to calculating capital gains taxes. Okay, you've got a townhouse that was purchased in 1970 for $100,000, and today it's worth $3.5 million. Now, if you inherit this because you either didn't have a plan or you inherited this through a will, then what happens is you receive this step up in basis. And instead of paying the difference between $100,000 and $3.5 million, instead of that being the basis of the calculation for whether you gained or lost money from this sale. The difference is calculated from the date of death, person who passed. So say the person who passed, when they passed, the house was worth $3.4 million. By the time you get around to selling it, it's worth $3.6 million. Then the capital gains tax is calculated only on that $200,000 difference. And that is the case if the property is passing without a will, you made no plan, if the property is passing through a will, and if the property is passing through a revocable trust. Because remember, a revocable trust will allow you to retain total control during your lifetime. So it's as if it was still owned by the person who passed in their own name. It is treated the same for the purposes of capital gains tax as well. However, if that property had been transferred into an irrevocable trust, such as a Medicaid trust, it is looked at as a gift was made during the lifetime, and it is no longer looked at as an inheritance. And when it becomes time to calculate capital gains tax, yes, you are going to have to be responsible for the differential between $100,000 and $3.6 million. So this is also something that comes into play when people may ask you, Ursulia, I receive calls like, can you just put my son on the deed? I don't want the house to go through probate. And that would have the same problem for capital gains taxes, because when people call me like that, I ask them, okay, but what did you buy it for? And they say things like $100,000 back in 1980. And I say, what is it worth now? And they say, oh, about $1 million. And if their son would inherit that home, they would have the benefit of that step up in basis, right? And only pay the difference between $100,000, between $1 million and the $1.2 million that it sells for. But if you put someone on the deed, then you are, unfortunately, without really thinking about it, creating a situation where the transfer is done during the lifetime. Half of it during the lifetime when the person is usually put on the deed as a half owner, and then half of it again at death. But these are all things that you can see are getting into the weeds, getting really complicated. And the main point is you don't make, hopefully, a decision like this just because a friend of yours put their kid on the deed, or you heard that probate is something to avoid, or you heard that maybe a Medicaid trust is a good idea. The way to make decisions like this is to really consult someone who can guide you through that process and help you figure out, based on your circumstances, right, what's best for you. Maybe if you just bought the house yesterday, you don't care as much, right? You bought the house yesterday, it was worth $700,000 then. You expect, maybe when you pass, it'll be worth $800,000. That's a different calculation than our house in 1970 that was purchased for $100,000.
That's right. That's
Yeah.
right.
That's
All right,
quite
you're
a
going to have to
difference.
do a lot of work with this section. Taxes are very hard to try to sort through in a system like this.
Yeah, that's a lot of information. And a lot of people don't realize, because I know for myself, I'm sure you as well, Ursulia, I get a lot of calls for people wanting to add someone to a deed or just change things up. They definitely think it's like a one and done quick thing that just needs to be filed with the clerk's office. But there's all these consequences, like Bracha just told us. So it's really great to have that information. So Bracha, what advice would you give for a first-time buyer who is kind of like, what should I do? Should I put this in me and my spouse's name? Should we buy this in a trust? Should we buy it first and put it in a trust? Do we need a trust? I mean, what do you think would be the best thing?
If you can consult a trust and estate attorney from the outset, you will be in a much better place. So rather than you just want to get to the closing, you just want to buy the house, you'll worry about it later, There are a couple problems with that. Oh, I'll put it in a trust later. It's hard for later to actually happen. We all have very busy lives. And once you are busy with your closing and you're busy with packing and you're busy with moving, to later say, oh, let me go find another lawyer and let me set up a trust and transfer the house into a trust, that really may not get done at all, quite possibly. And the other problem is if you do that, if you make the transfer afterwards, you are going to have to pay title company fees again, which could be about $600. You're going to probably end up paying $1,000 at least in legal fees, possibly a couple thousand more, because somebody has to trace back and look at, okay, you bought the deed in what kind of ownership is this? Did you buy it with your spouse? Did you buy it with someone else? What happened here? And what kind of trust do I need to create if you want to carry through that form of ownership, if you want to change that form of ownership? Ideally, if at the point where you've identified a property that you want to buy, you can have your trust and estate attorney work closely with your real estate attorney, you are in a much better place to set up a vehicle right there. Your trust and estate attorney can counsel you on which kind of trust is right for you, of the ones we've spoken about. And then you make sure it's done right. You also make sure that the property is actually put into the trust, because it is not unusual, unfortunately, for people to set up fancy trusts, but never actually put the property in them. And unfortunately, that even happens when lawyers do it, because it's the kind of detail that sometimes gets forgotten. Unfortunately, we do see cases often when trusts have been set up for clients, and when someone passes, then they come to our office and we check the deed, right? We have to pull the deed. The deed just says that the house is still in the person's personal name. It never made it into the trust. So if you can do it like anything else, if you can do something from the outset, if you can have your players communicate with each other, your trust and estate attorney, your real estate attorney, you're usually going to get a better result. You're going to make sure it gets done, and you're going to make sure it gets done right.
Bracha, thank you so much for this very, very interesting insight. I really enjoyed talking with you and receiving all this information that very strictly intersects with our field, being real estate attorneys. I would like to encourage all who listen to our podcast today that if you have any further questions, please feel free to reach out to Bracha. Her website is brachalaw.com. It will be posted on our website, rocktheclosing.com. And both Dalia and myself, we are working with Bracha very, very closely together. So we are more than happy. If you need a real estate attorney, be rest assured that we will be involving Bracha to give you more options, and vice versa. So again, real estate attorneys and trust and estate attorneys are often working together. And this is something that should be your final takeaway when you embark on a real estate transaction in your life. Once again, thank you so much for chiming in for today's Rock the Closing. Hope to see you in our next episode.
Thank you.
Thank you for tuning in to Rock the Closing. This podcast is hosted by real estate attorneys who offer valuable insights. Please remember that the content is for educational purposes only and does not constitute legal advice. Always consult a qualified professional before making any decisions. This podcast is copyrighted by Rock the Closing, and any reproduction, syndication, or rebroadcasting of the content requires written permission.